In today's world, protecting our assets from unwanted lawsuits and ambulance chasers is a top priority, and therefore setting up corporate structures the right way and properly is more important than ever. Many of our clients come to us and they'll tell me, Javier, I'm covered in terms of asset protection. I set up an LLC. I set up a corporation. That means I'm good, right? And I would answer, you know what? You're good. It's functional, provided that you follow the steps that I'm going to outline in this video. So if you want to make sure that your corporate structure is properly set up and that it is actually protecting you and you don't have just the illusion of protection, then this video is for you. So many of you might be familiar with the concept of the corporate shield, meaning or whereby if I have a business and I do all of my business through my corporate entity, then that means that I, as the shareholder or as the member in the case of LLCs, am fully protected in terms of liability. So let's say, for example, Javier, if I set up Javier LLC or Javier Corporation and I do business through those entities, then in theory, if one of those entities gets in trouble, if a client sues one of those entities, or if any other problem should arise, then in theory, the person suing the entity can only access the assets owned by those entities. And I, Javier, as the individual member or shareholder, should be protected as the owner. My personal assets should be off limits to the judgment creditor or to creditors in general when I set up a business entity. Now, this is true, but we have to understand that this is true on a general, in a general way, and we have to understand where the concept of the corporate shield comes from to actually view when it might be pierced, when there might be a lifting of the corporate veil, and therefore make the corporate structure not necessarily as solid as you think it may be. So let's take a closer look at that. Where does the corporate shield come from? The corporate shield comes from the fact that in legal terms, corporations are normally considered as independent persons for legal purposes. They are considered to have their own debts, their own liabilities, and their own legal personalities, meaning that having a corporation should be no different than, having your best friend John right next to you. So if you have your best friend John right next to you, John has his own history, his own name, his own identity, the things he likes, the things he doesn't like, and that gives John personality. And the same thing happens with a corporation or an LLC. LLCs normally are required to have their own identities, to have their own independent personalities, and to be distinct from their owners. And this is the key aspect. If your business is truly independent and truly distinct from you as an individual, then you are okay. However, if a judge can determine that a business is actually serving as your alter ego, meaning that you've set up a corporation, you've set up an LLC, but when you look at the facts, it's just you operating through that company, but that company really doesn't serve any purpose other than just being there for asset protection purposes or for tax purposes, then honestly, what may happen is that the judge might authorize your creditor to pierce the corporate veil, to look through the entity, and to go after your personal assets. Now, how do you make sure that a judge or an arbitrator or whomever it may be does not consider that your company is just simply serving as an alter ego? In order to do this, you have to make sure that certain formalities are followed. Now, this video is not intended to be legal advice, so if you do have a specific situation and you do have a specific risk of being sued, I do recommend you contact your local attorney as quickly as possible to make sure that you are protected in your jurisdiction. It is also important to take into consideration that different jurisdictions might have different regulations, and what I am about to discuss here are just general concepts of corporate law that might be applied as general principles around the world, but each jurisdiction, each country, each territory might have variations, deviations based on case law. So with that being said, and with that disclaimer out of the way, let's get right on it. So what formalities should I follow to make sure that my company or my LLC will fully protect me? So number one of the key aspects of having your company have its own personality is all of the contracts have to be signed using company name. So if you're going to do business through your LLC or your corp, then make sure that all contracts, the person entering into that contract is your corporation and LLC and not you personally. So if you sign the contract, for example, me, Javier, as an individual, and I just direct the payments to be made to an LLC or a corporation, that's not enough. The actual contract has to be between your business and your client. It should also always be specified that you are signing the contract as a human, acting in your capacity as director, managing partner, CEO, CFO, or whatever your corporate title may be, but you always have to make sure that it is clearly established that you, as the human, are just acting as the officer of the corporation, and you're signing on behalf of your corporation or LLC, and not you as an individual for individual business purposes. That's number one. Number two, corporate formalities must always be observed. And this is fundamental because I see a lot of closely held companies, a lot of personal investment companies, or a lot of family businesses where, you don't have shareholders who don't know each other. Often the shareholder is either one person in the case of personal holding companies, or it's simply family members that obviously intimately know each other. It's a husband and wife. It's a father and his children. And therefore they say, well, why do we need to have a shareholders meeting? Why do we need to have a board of directors meeting? In the case of LLCs, why do we need to have an operating agreement? We know each other. At the end of the day, we're family here. Or listen, some clients have even told me, Javier, it's just me. Like, why do I need to have a shareholders meeting or an operating agreement for an LLC if I'm the only guy who owns the business? And the answer is to avoid the company being treated as your alter ego. That's the whole point of this. So part of making sure that your company, whether it be an LLC or a corp, has its own personality is making sure that all of these formalities are being kept and that they are being respected. So in the case of corporations, shareholders meeting at least one per year, and every important decision should go through a shareholders meeting or a board of directors meeting, depending on how your statutes have been drawn up. And you should make sure that those meetings are well documented, that you have meeting minutes, and you should keep company records. In fact, that is another very important point. Company records should always be kept clear, neat, and you should avoid being in a situation whereby you say, well, I wasn't keeping company records because at the end of the day, me and the company, we don't have a real difference. I can just take out money from the company account. I'm the only one making all the decisions. So no need to keep records because I don't have to basically provide this information to anyone else. I don't have to be audited by anyone else. So in many cases, when it's one shareholder or a family business, these formalities are not observed, and this might cause immense issues. So it is fundamental for your company, in the case of corporations, to have board of directors meetings, shareholder meetings, and these have to be well documented. And in the case of LLCs, you should also make sure that you have meeting minutes. Another important aspect here is asset commingling and distributions. So let's start with distributions for a moment. So in the case of distributions, what this means is that you should definitely avoid using your company as your piggy bank, which means that even if you're the only shareholder or only member, or maybe it's just a family LLC and you and your wife are the members or whatnot, you should always make sure that when you need to take capital out of your LLC or corp, again, it is well documented and it is properly done. It can be a dividend in the case of corporations or LLCs with C Corp election in the US, for example. It can be a K1 capital distribution in the US. It can be, in general, just capital distributions if it's a partnership or a pass-through entity. It can even be a loan to members or shareholders. But the important thing is that everything has to be well documented. So it's not a situation whereby you want to buy a beautiful piece of jewelry for your wife, or you want to take a trip to Paris, and all you do is just take the money out of the company account as you need it, when you need it, and just spend it at your own whim. You have to make sure that the money you're taking out of your company is for a specific purpose, and it has to be rewarding either your capital contribution to the company, your membership stake in the company, your stock in the company, or your work. You can also take money out as a salary. If you're going to issue loans to yourself, you have to make sure that those loans, even if it's between your company and yourself, those loans are done at fair market value, and that you're actually paying back the loans at a fair market interest rate. So you can't really deal with yourself and your company unless you're doing it at arm's length and you're respecting the rate, the governing rate of the market at the time. The same thing happens with your salary. You should always make sure that your salary is adjusted and competitive compared to market rates. You can't overpay a salary. You shouldn't underpay a salary either. If you're performing the duties of a director, you should look at what are directors making in, comparable roles within the industry, and make sure that your salary is adjusted for fair market value, to make sure that you can always argue that your company is acting as an independent person, and that if you were not hired and somebody else was hired, you would be paying a similar salary, a similar wage, or a similar type of compensation. Now, talking about commingling of assets, this is a topic that is closely related to distributions. Commingling of assets essentially means that the assets that are held in the business should be used for business purposes. So you shouldn't mix your personal assets with your business assets, meaning that if you have a company and you buy a home within that entity and then you only use it for personal purposes, or you buy a vehicle and then you only use it for personal purposes, then that's going to be a big problem later on, because if a judge determines that you've been commingling assets, that actually weakens the corporate protection that a business entity may provide. So you should really make sure that your business entity only has assets that are legitimately being used for business purposes. You can set up a separate entity if you like, just to hold personal property or to hold some personal investments, and that can be part of your overall corporate structure. In fact, we help people here at Nomad Capitalist set those up all the time, where you have multiple entities for multiple purposes. But specifically, your entity doing business with third-party clients should never have assets inside of it that are being used for personal purposes. Now, with all this being said, provided that you follow all these formalities that I've just laid out, and many more, surely, depending on the jurisdiction in which you're located. Again, remember, if you have a specific issue, do consult with your attorney. But having all this in mind, exactly now, what happens when you want to choose the best entity for asset protection? Well, when you want to choose the best entity for asset protection, there are multiple jurisdictions you can choose from. I believe that one of the ones that are most worthy of note, if you're really looking for that top tier, strong, super strong asset protection, would maybe be the Nevis and the Cook Islands LLCs. We help clients set those up all the time. And in fact, I'm just going to give you a small teaser as to how they work, so that you'll tune into the next video when we're going to talk about all these LLCs in detail, and you're going to see how wonderful they are. But essentially, we talked a lot about the corporate veil throughout this video, and we talked about how your company can protect you if the company is being sued for some kind of business issue, and that you're protected as the owner. But what happens when things occur the other way around? What happens if you get into trouble and the creditor is trying to take your company away? Well, if you have a corporation and you have shares, those assets might potentially be taken away, just like your car can be taken away or your home can be taken away. But what happens with LLCs? With LLCs in Nevis and the Cook Islands, you have something called charging order protection. And I'm not going to get into details here, because remember, we have a video coming up on this. But charging order protection essentially puts your company, your LLC membership interest beyond the reach of creditors if things are done properly. And you can potentially avoid, even if you get into trouble personally, you can avoid your company and all of the assets held inside your company from being taken away from you, which is a great advantage. Now, US LLCs also provide charging order protection, but not nearly as strong as Nevis or the Cook Islands. US LLCs can also provide tremendous benefits in this regard, but if you're looking for the top tier, best of the best, strongest possible asset protection, then definitely Nevis and the Cook Islands do deserve your attention, and you're going to love our next video. Now, having said all this, if you want to learn more about asset protection, if you want to learn more about corporate entities, if you want to make sure that your corporate entity is protecting you in the right manner, in the right way, then nomadcapitalist.com/apply. Subscribe to this YouTube channel, follow us on Instagram, and I'll see you with the LLCs in the next video.